Ah, the Homeowners Association, the HOA. For some people, they're the guardians of property values. And for others, well, they're a total nightmare. That friction is super common, but what happens when it goes from just angry emails to a full-blown lawsuit? We're about to dive into a real-life case to see exactly what goes down.
It's a question I bet a lot of you have wondered, right? So we're going to peel back the curtain on one homeowner's 4-year legal battle to find out what it really takes to win or, lose against the board.
So, our story kicks off in a planned community down in Anthem, Arizona. A homeowner had to get his backyard landscaping done within 120 days of buying his house. A pretty standard rule. But what started as this simple requirement, it just spiraled into this multi-year legal saga. Let's just walk through the timeline to see how this thing got so out of hand. Okay, so the house is purchased in late 2017. The first landscaping plans, they don't even get submitted until August 2018, way after the deadline. Then, for the next year and a half, it's this back and forth, plan changes, notices. Then, in December 2019, the HOA makes a really simple request. Hey, just send us a photo to show the work is done. And what do they get back? Crickets. Radio silence. More than a year later, in March 2021, it's the homeowner who turns around and files a lawsuit.
So here's the real sticking point. The homeowner tells the HOA board, my yard's finished. It's been done for months. But the HOA, based on their own inspections, is saying, no, it's not. And that stalemate is what launched this whole thing from just violation notices straight into the legal system. So the homeowner, Mr. Gragg, he didn't just file some vague complaint. Nope. He structured his lawsuit around 4 very specific allegations, claiming the HOA had broken state laws and its own rules. This is where the battle lines were officially drawn. His entire case rested on these 4 key claims. First, he argued the HOA was practicing selective enforcement, basically just picking on him. Second, that they were just inventing violations. Third, they were illegally withholding records he was supposed to be able to see. And fourth, they improperly refused to mediate the dispute. So let's break these down one by one. Okay, let's tackle those first 2 claims because they're all about fairness. Was the HOA really singling this guy out? Were they fining him for stuff they didn't even see? This is really the emotional heart of his whole argument. The homeowner's whole selective enforcement claim, it pretty much all came down to that request for a photo. He argued, this is totally unfair, no one else has to do this. But the HOA? Oh, they came prepared. They showed up with a decade's worth of records showing they had made the exact same request to other homeowners who weren't compliant. And this right here just shows you the power of documentation. The judge basically said the homeowner completely failed to prove the HOA violated its own rules, the CC&Rs, which are the covenants, conditions, and restrictions that govern the whole community. The HOA had the paperwork to prove they were consistent. The evidence was crystal clear, and that claim got tossed. So what about that second claim, the one about fraudulent violations? Well, that one got shot down just as fast. The judge found that, far from being unobserved, the violations were all noted and documented by the HOA's own community standards administrator during their regular drive-throughs of the neighborhood. So yeah, that claim failed too. All right, so the claims about unfair enforcement totally fizzled. So the case then pivoted to procedure. The homeowner argued that, hey, even if he was wrong about the landscaping, the HOA didn't follow the proper process. He claimed they illegally withheld records and refused his request for mediation. Now, this is a super critical legal distinction. Under Arizona law, an HOA has to give you copies of its official records, things like meeting minutes or budgets. But what it's not required to do is answer your legal questions for you. They don't have to do your homework and point out the exact section in the rulebook that gives them the authority to do something. And wouldn't you know it, that's exactly what the judge found here. The homeowner hadn't asked for a specific document. He'd asked the HOA to justify its actions, to prove where it got its authority. Those were questions, not records requests, and the law just didn't require the HOA to answer them. Boom, another claim down. So that brings us to the last claim, and you might be thinking, this seems like a reasonable question, right? I mean, wouldn't mediation just be the best way to solve this whole mess? The homeowner sure thought so, and he accused the HOA of improperly saying no. But once again, it all comes down to the documents. The community's own CC&Rs, the very rules the homeowner agreed to when he bought the house, had a list of disputes that were specifically excluded from mandatory arbitration. And right there on that list, enforcing the design guidelines. This whole case was about landscaping rules, which falls right under that exclusion.
So, as you can probably guess by now, the homeowner lost on all 4 counts. I mean, it wasn't even close. But the reason he lost is the most important lesson in this entire explainer, and it boils down to a fundamental legal standard.
See, in a civil case like this, the person who's suing has what's called the burden of proof. They have to prove their claims by a preponderance of the evidence. It sounds fancy, but it just means you have to convince the judge that your side of the story is more likely to be true than not, even if it's just by a hair, like 51% to 49%. And that's the bottom line. The homeowner made a lot of allegations, but he just didn't bring the receipts. He didn't have enough convincing evidence to meet that more likely than not standard for a single one of his 4 claims. The HOA, on the other hand, had documents, records, and a paper trail of consistent enforcement. So, to sum it all up, he walked into court with 4 distinct claims against his HOA.
And he walked out having failed to prove a single one.
The final order from the administrative law judge was simple, direct, and absolute. The homeowner's petition was denied. Case closed. This whole case really boils down to one powerful takeaway question. In a dispute with your HOA, or really in any legal fight, what actually matters more, how you feel or what you can prove? And I think this case gives us a very, very clear answer to that.